Hello all, welcome to Paritranaya. In this video, we shall discuss about Supreme Court and High Court judges. With respect to these judges, we shall look into the total strength, qualifications required, and the appointment procedure involved. Here, we will be discussing through comparison. We will be comparing the Supreme Court judges with High Court judges. So when we learn through such kind of comparison, then we can retain the information for a very long period of time. So let's begin with the strength. So what does strength indicate? Strength indicate the total number of judges present in Supreme Court and total number of judges present in High Court. So in Supreme Court, we will be having one Chief Justice of India and other judges. Similarly, in states, we will be having one Chief Justice of State and other judges. So let us look into number of judges of Supreme Court. When it comes to Supreme Court, initially when Supreme Court came into being, there was one Chief Justice of India and 7 other judges originally. Next, how can we increase the number of judges of the Supreme Court? In order to increase the number of judges of the Supreme Court, Parliament is empowered. So Parliament is empowered in the sense Parliament can increase the number of judges in the Supreme Court. How? By passing a bill. So when it comes to bill, we know that there are different types of bills. For example, ordinary bill, constitutional amendment bill, finance bill and all. So what kind of bill will be required to increase the number of judges? Ordinary bill. So through an ordinary act, we will be able to increase the number of judges in the Supreme Court. So present strength in the Supreme Court is 34, including Chief Justice of India. Now when it comes to High Court, we have one Chief Justice of a High Court. We will be having one Chief Justice plus such other numbers. So it varies from state to state. So the number of judges available in Karnataka may not be the same the number of judges available in Punjab, Manipur, elsewhere. So here, who will decide that how many judges should be there in a particular High Court? It is the discretion of President. So President will decide how many judges should be there in a particular High Court. So based on workload. So this is a very, very important difference that we need to understand. When it comes to increasing the number of judges in the Supreme Court, who is empowered? Parliament is empowered. But when it comes to increasing the number of judges in the High Court, who is empowered? President. So President can increase the number of judges in the High Court based on the workload. So this was about number of judges. Next, qualifications. So let us again learn through comparison. In order to become a judge of the Supreme Court, he should be a citizen of India. So it's very much obvious. Next, apart from that, he should have either served as a judge in High Court for 5 years. He should have served as a judge in High Court for 5 years, or he should have worked in High Court as an advocate for 10 years. If any one of these conditions is satisfied, then it's okay. One is citizen of India. Next, either High Court judge for 5 years or advocate in High Court for 10 years. Next, there is another provision. A distinguished jurist in the eyes of President. For time being, we shall not worry about what is this distinguished jurist and all, but there is a provision that a distinguished jurist in the eyes of the President, he can be appointed as a judge of Supreme Court. Next, what are the qualifications required to become judge of High Court? Same, he should be citizen of India. Next, held a judicial office in the territory of India for 10 years. So what is judicial office? For time being, don't worry about it. Later on we shall see. So a person, he should have held some judicial office in the territory of India. That is very important. Territory of India, within India, not outside India, for 10 years. Next, or a person who has served in High Court as advocate for 10 years. A person who has served in High Court as advocate for 10 years, even he can be appointed. Next, very important, there is no jurist here. In case of Supreme Court, a distinguished jurist in the eyes of the President could be appointed as a judge of the Supreme Court. But there is no such provision in case of High Court. Very important. Very important. Next, who will appoint the judge of the Supreme Court? President will appoint judge of the Supreme Court. Similarly, in case of Judge of High Court, President will appoint Judge of High Court as well. Next, can President appoint anyone as Judge of the High Court? Or does he need to consult anyone? Yes, he needs consultation. So to whom he has to consult? Again, it varies with respect to Chief Justice of India and Chief Justice of High Court and other normal judges. So let us first look into the consultation with respect to Chief Justice of India appointment. It means when President wants to appoint Chief Justice of India, when President wants to appoint Chief Justice of India, then here he has to consult some people. He has to consult some people. Whom he has to consult? So as per the constitution, it says that President should consult such judges of Supreme Court and High Court as he deems necessary. So it is not mentioned how many judges of Supreme Court he has to consult, how many judges of High Court he has to consult. It is not mentioned clearly. It is only mentioned that as many judges of Supreme Court and as many judges of High Court he can consult as he feels it necessary. Next, similarly, when it comes to appointing Chief Justice of a High Court, President has to consult Chief Justice of India. He has to consult the governor. He has to consult the governor of a state of which Chief Justice is being appointed. And later on, we'll see that we can have a common High Court for 2 or more states. So if there is a common High Court for 2 or more states, then we'll be having multiple governors. So in that case, we have to consult the governors of all the states. This is with respect to appointment of Chief Justice of High Court. Next, in second judge case, so these cases are very important. So whatever the judgments the Supreme Court gives, so the government or the whole of the nation has to abide by it. We have to follow by it. So in the second judge case, it said that only senior to be made Chief Justice of India. Only senior most judge can be made as Chief Justice of India. So now this consultation and all, it will become what, just a namesake. Whosoever is the senior, he will be appointed as Chief Justice of India. So such kind of provision does not apply to appointment of Chief Justice of a High Court. Important. Next. So there we saw appointment of Chief Justice of India and appointment of Chief Justice of High Court. Next we shall see the appointment of other judges. Okay. Again, who will appoint here? President will appoint. But before appointing, President has to consult. So to whom he has to consult? So when other judges are being appointed, President has to consult. Whom? He has to consult Chief Justice of India. Next, other judges of the Supreme Court and High Court as he deems necessary. So the Constitution has not given any clear information. It says that apart from the Chief Justice of India, when President is appointing other judges of the Supreme Court, he has to consult Chief Justice of India and as many judges of Supreme Court and High Court as he feels necessary. Similarly, for appointing other judges of the High Courts, President has to consult Chief Justice of India. He has to consult the governor of that particular state, and if we have a common High Court for more than one state, then we will consult the governors of all the states. Next, apart from that, President should also consult Chief Justice of that particular High Court. So to whichever High Court we are making the appointments of judges, we should also consult the Chief Justice of that particular High Court. Important. Next, here also we have third judge's case, very important. Okay, third judge's case, very important. So we know that President will appoint the judges. Now in case of Supreme Court, whom he has to consult? He has to consult Chief Justice of India and such other judges of Supreme Court and High Court as he deems necessary. So Constitution has not given any clear idea. But the third judge's case, it is clearly mentioned. What it has mentioned? So Chief Justice of India, he has to give the recommendation to President. That you appoint the following people as judges of the Supreme Court. But when Chief Justice of India is giving recommendation to President, when Chief Justice of India is giving a recommendation to President, he alone individually cannot give the recommendation. So before that, he has to consult 4 senior most judges. So Senior Judge 1, Senior Judge 2, Senior Judge 3, Senior Judge 4. So before sending the recommendation, Chief Justice of India has to consult 4 senior most judges. 4 senior most judges. After consulting them, then he has to send the names to President. Names to President. CJI should consult 4 senior most judges of 4 senior most Supreme Court judges. Very important. Even if 2 judges give adverse opinion, he should not send recommendation to the government. It means among the 4 people, among the 4 senior most judges whom CJI has consulted, if 3 of them are okay, then no problem. He will send the recommendation to President and President will go for the appointment. But if 2 of them are opposed to it, let us assume among the 4 members, if 2 of them are opposed to the appointments, then CJI should not send the recommendation to President. CJI should not send the recommendation to President. Even if CJI sends the recommendation in that case, so President is not bound. President is not bound. So in the other case, if all the 4 members agree, then and in that case when the CJI sends a recommendation to President, it is binding on President. But now if at least 2 members they disagree, then even if the President sends, the Chief Justice of India sends a recommendation to President, it is not binding. It is not binding on him. So even if 2 judges give adverse opinion, he should not send recommendation to the government. The government in the sense President. So if not done, then it's not binding on government. That is, irrespective of these differences, if the CJI sends the recommendation to President, then it is not binding on President or government. Okay, government. So here government is nothing but we are referring to President. Next, similarly in 3rd judge's case, when it comes to appointment of other judges of the High Court, President should consult CJI. So President who will send the recommendation? Chief Justice of India. But here in this case, Chief Justice of India should consult 2 senior most judges of Supreme Court. 2 senior most judges of Supreme Court. Okay. Very important. So in case of appointment of other judges of Supreme Court, CJI should consult 4 senior most judges, whereas in case of appointment of other judges of High Courts, he has to consult 2 senior most judges. 2 senior most judges. So this was about the Supreme Court versus High Court judges. So we saw the total strength of the judges. We discussed about the qualifications required, and we also discussed about the appointment procedure involved. So similarly, in the subsequent videos, we'll be discussing about the other important topics related to polity. For all our further updates, subscribe to our channel and hit on the bell icon. Thank you.